Item number 1.
Yes, please.
Your Lordship, we are supposed to file a paper book, so I'm seeking 2 weeks' time, Your Lordship, to file a paper book.
Yes.
Yes, Your Lordship. Your Lordship, we are supposed to file a paper book. So I'm
Then?
seeking 2 weeks' time, Your Lordship.
Hmm?
I'm seeking 2 weeks'
Do
time,
you
Your
know
Lordship.
the consequences of not filing a paper book within time? You know the consequences? What is the consequence?
Last chance, Your Lordship.
No, what is the consequence?
I'm not aware of it, Your Lordship.
Your appeal is liable to be dismissed for non-prosecution. Don't take it so easily.
I apologize, Your Lordship.
When can you file it?
After 2 weeks, Your Lordship, positively.
Giving them 2 weeks. The appellant's advocate on record has not filed the paper book. In terms of our order dated 22nd November 2024. Next. Time to file the paper book is peremptorily extended till 10th March. Next line, service of the paper book on the respondent's advocate on record is to be effected by the above date. List this appeal for hearing on 18 March. Next. We make it clear that if the paper book is not filed by the aforesaid date, the appeal would be liable to be dismissed for non-prosecution.
Item number 2.
All right, you cut out the last line.
May I please, Your Lordship? Lordship, I pray for 2 weeks more time, Lordship.
Sorry?
I pray for 2 weeks more time, Your Lordship.
You are appealing for?
Respondent, Your Lordship.
Yes.
I pray for 2 more weeks time, Lordship.
Please speak louder.
I pray for 2 more weeks time, Lordship.
But she's praying for 2 weeks' time, my lord.
The appeal is ready for hearing.
My lord, it's ready.
What do you say?
Paper book has already been filed.
What do you say?
Time may be granted. No objection.
On the prayer of learned advocate for the respondent for adjournment of this appeal for 2 weeks, which is not opposed by learned advocate for the appellants. This appeal is adjourned till 11th March.
Item number 3.
Obliged.
Your Lordship. Lordship.
Yes.
Ready, Lordship.
Ready?
Lordship.
Ready. Okay. Short Passover. Yes. Call the other items.
Item number 4. May it please His Lordship. Lordship, I pray for some accommodation in this matter, Your Lordship.
Yes.
Yes. Can I start?
She is asking for adjournment.
Adjournment.
Your Lordship, if it can come next week, Your Lordship.
My lord, is all the time it is.
What is this matter about?
This is regarding reimbursement of OPT bill.
Oh.
Reimbursement of OPT bill for dialysis patient.
Why are you praying for adjournment?
Your Lordship, as the conducting counsel and DHI.
Sorry?
Your Lordship, as the learned DHI is on legs, Your Lordship.
Please speak. It is not audible, the voices.
Your Lordship, as the conducting counsel, Dr. N. Mozika, Your Lordship.
Yes.
He has some personal difficulty, Your Lordship.
You do it tomorrow,
Yes. Yes, please.
not today.
Okay. Much obliged.
On the prayer of learned advocate for the respondents. This appeal is adjourned for the day.
Okay. Much obliged.
Much obliged, Lordship.
Item number 5 to 15.
Hey, please, Your Lordship. Your Lordship, I'm seeking some accommodation in this matter, Your
You are
Lordship,
appealing for whom?
for the appellant, Your Lordship.
Why?
Lordship, the conducting counsel, double AG, is on legs in the order.
You proceed with the matter.
Lordship, he is also facing some personal difficulties, Your Lordship.
He is on his legs, he is facing personal difficulties. How do you reconcile the two? Huh?
Apologies.
All right, on the prayer of learned counsel for the appellants, this appeal is adjourned for the day. Tomorrow do it. Let's call the Passover item.
Second call,
Tomorrow we
item,
will take it.
second call, item number 3.
Lordship, like-
May I start, Lordship?
Yes.
Lordship, first, Lordship, I'll like to draw Lordship attention on the judgment, Lordship.
Yes.
Para 13 is the relevant portion of the judgment, Lordship. May I, Lordship? Lordship, though the Act provides for
Page.
page number 148, last page, Lordship. Para 13, last page.
Yes.
Yes. Though the Act provides for alternate remedy by way of an appeal under Section 7I against order passed under Section 14B in the considered view of this court, the impugned order which suffered from arbitrariness, non-consideration of the circumstances as put forth by the petitioner by letter dated 25/5/2022 and passed in a mechanical fashion without any application of mind as to whether the power as vested had been exercised within reasonable time deserves to be interfered by this court in exercise of power under Article 226 of the Constitution of India. Accordingly, in the given facts and circumstances, and as discussed above, the instant writ petition is allowed and the impugned notice dated 21/10/2021 and both the order dated 3/2/2023 under Section 14B and 7Q are accordingly set aside and quashed. Lordship, here what happened, we have the Employees Provident Fund, we have issued summon from on 21/10/2021 and thereby after a brief hearing on the matter, we have passed order under Section 14B 7Q on 3/2/2023, Lordship. Now, Lordship, if the Act is available with Lordship, EPF Act. As per the Act, Lordship, 7I. Lordship, may I please?
Yes.
Lordship, appeal to tribunal. Any person aggrieved by a notification issued by the central government or an order passed by the central government or any statutory, any authority under the provision of subsection 3 or subsection 3 or subsection 4 of section 1 or section 3 or subsection 1 of 7A or section 7B, except an order rejecting an application for review referred to in subsection 5 thereof or section 7C or section 14B, may prefer an appeal to a tribunal against such notification or order. So, Lordship, here, since I have passed an order under section 14B, so this is an appealable order to the appellate tribunal and not to be interfered by the High Court under 226. Further, in the section says, every appeal under subsection 1 shall be filed in such form and manner within such time and may be accompanied by such fees as may be prescribed. So to
Show us 14B.
14B. Power to recover damage. Where an employer makes default in the payment of any contribution to the fund, the pension fund, including the pension fund, or the insurance fund, or in the transfer of accumulation required to be transferred by him under subsection 2 of section 15 or subsection 5 of section 17, or in the payment of any charges payable under any other provision of this act, or of any scheme or insurance schemes, or under any of the condition specified under section 17. The central government, the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme, provided that before levying and recovering such damages, the employer shall be given a reasonable opportunity of being heard. Provided further that the central board may reduce or waive the damages levied under this section in relation to an establishment which is a sick industrial company and in respect of which a scheme for rehabilitation has been sanctioned by the Board for Industrial and Financial Reconstruction establishment under section 4 of the Sick Industrial Companies Special Provision Act 1985, 1 of 1986, subject to such terms and conditions as may be specified in the scheme. So, Lordship, before passing any order, we have given the respondent ample opportunity of being heard by subsequently fixing the date where they are to provide the necessary relevant documents pertaining to their dues which they have deposited. After due consideration, we have passed the order under section 14B and 7Q, Lordship.
So what's your order?
Lordship, our order is page 105. May I, Lordship? Lordship, in 100 also, Lordship, we have passed order under section 14B. And in 105, it's 7Q, Lordship.
105 is a 14B order.
105 is 7Q and 100 is 14B. It's a lengthy order, Lordship. May I please, Lordship? May I, Lordship?
You have claimed the actual amounts only.
Lordship, we have made after due consideration of during hearing, we have given them
On what basis you have calculated this?
Lordship, it is as per the damages which the damages are calculated on number of days delays, Lordship. Lordship, the number, Lordship, if I draw your Lordship attention to, for example, page 64 and 65, Lordship. Let's bring come to page 64, Lordship. For example, to damage, how we calculate, Lordship. This is under for the column is made, Lordship. If we take 395, first column, Lordship, first row, 395, the amount paid you is amount to be paid on 15/4/1995, which they have deposited on 15/9/2004, Lordship. So it's a huge delay on paying the dues. After calculating everything, we have given them the revised calculation sheet also, Lordship. So now under section 14B and 7Q, first is 7Q to 2,633 rupees, and 14B is 3,441 rupees. So in this way, we have calculated we have given them the total calculation, how we have made the calculation. Then we have provided them after consideration of during hearing process, we have when
2633 was the amount due.
2633 was the amount due. Then later, number of delay days. 2633 is the number of delay days, and the amount account 1, account 2. It's the pension fund is also there, and provident fund is also there. So in account 2, they are to deposit 7,962, and in account 21, 22,119, and account 22, 444. So total comes to 30,523. So this is how we have calculated. This is the number of days delay.
What are the grounds in the writ?
The grounds where they have there is a change in the CDA to IDA pattern, number 1. Number 2 is that it is from 1995, so they don't possess all the accounts which they have, the deposits what they have made. They don't have all the papers along with them. These are the main 2 grounds. But for us, Lordship, while we were conducting the hearing, while we were passing the orders, we have taken into
This calculation is part of the impugned order.
the calculations were the calculations were not part of the impugned. From the calculation, we have derived the impugned order.
Where have you stated that in the impugned order?
Lordship, page number 101.
Please read out what you have stated.
The issue related to the arrear EPS deposits for the periods of 95, 96, 96, 97, 97, 98, 98, 99, 99, 2000, 2020, 2001, which was deposited on 8/3/2001 were taken up. And later on, we have also, subsequently, we have also reflected. Then we have also stated that on verification of the challan submitted by the establishment, it is seen that from the wage month 1 2001, 2 2002, 5 2002, 8 2002, 12 2002, 4 2003, 6 2003.
Now please come back to page 64 or 24, whatever it is, that calculation. The first entry is delay, number of days delay.
Yes.
All right.
Yes.
And the second is damages.
Yes.
Now, on what basis you have calculated this damage?
Damages are, Lordship,
The section says not exceeding the amount due.
yes.
So, on what basis it is increasing the amount due? It is exceeding the amount due. Or it is not. But on what basis you have calculated 3441? Then second entry 1.
It is 3441 is delay days under section 7.
You said that 2623 is the delay days. The first
Delay days is the entire column, Lordship. It is delay days under section 7Q and 14B.
All right. Then where is the calculation of damage?
Lordship, the damage is calculated.
On the top right hand column, you are saying amount of 7Q 14B due. 7Q
delay
is
days,
amount, 14B is damage.
yes. 7Q is the interest and 14B is the damage. 7Q is the interest on the damage. Is that not amount? It's 7Q is the interest. Lordship, as per the act, if I draw Lordship.
All right. 7Q is
Interest.
79682. First item.
Yes, it's account 2.
And damage is
Damage is
9191.
yes, 7Q 9191 9198 is the damages on which the interest rate is 77962. It is 7Q is interest on the damages.
Yes. So how have you calculated the damages?
Damages is calculated on the number of days delays on Lordship. Here, page number 62. Page number 62. It's more specifically mentioned. Period of days delay, the column is there, Lordship. Period of days delay is less than 2 months, 17%. 2 months and above and less than 4 months, it's 22%. 4 months and above and less than 6 months, it's 27%. 6 months and above, it's 37%. It is up to 2008, and from 26/9/2008, there is a change, and subsequently 6 months and above comes to 25. So now if we take the calculation of 95 is prior to 2008, so it is coming to 37%. And subsequent...
You come to the section.
(14B), Lordship.
Yes. May recover from the employer by way of penalty such damages not exceeding the amount of arrears.
Lordship.
There is no method prescribed to calculate damages,
Lordship,
but it should not be more than the amount due.
more than the amount due.
So how have you calculated?
Lordship, Lordship, here, the subsequent column, it is already there, Lordship. Amount of damages, interest and total.
Page?
Page 62 only. Page 62, the subsequent column.
No, but how have you calculated this? 35,07,651. Or to be more specific, EPS contribution in account. That perhaps they have not made. Administrative charges, EDLI contribution, EDLI administrative inspection charges. So how have you calculated the damages?
It is like that, Lordship. Suppose it is based on the percentage. It depends on suppose for Lordship, it depends on the salary of the Lord.
We can understand, but it should be reflected in the order. You cannot improve an order from the bar.
Lordship, it is, Lordship, more specifically, Lordship, it happens so that when there might be 20 employees, but 20 employees drawing salary at not the same parity, Lordship. Their salaries are different, Lordship. So obviously, the amount which has to be deposited, Lordship, it is more specifically the employer knows, Lordship. We have calculated as part the employer deposited the amount. Because in that point of time, what is the, we have also nature of, in my order, Lordship 102, in my order 102 page number, we have already described in the column down, Lordship. EPF contribution, amount due is nil. Then administrative charges, then EPF, EPS contribution, that much account we have elaborately explained On what basis we have done, Lordship? Amount due is nil, Lordship, as on passing the order, Lordship. Lordship, in 102, we have reflected in the down portion, Lordship.
These are the two adjudication orders,
Lordship.
3-2-23.
Pardon, Lordship?
3-2-23.
Lordship, 3-2-23. 14B and 7Q. 14B is the damage, 7Q is the interest, and page number 106 of 7Q, we have in the table we have provided an explanation on how we have calculated the interest, Lordship.
But while setting aside the order, the learned judge did not order fresh adjudication.
No, my lord, because our challenge, my lord, was on completely different grounds. Lordship had asked a very pointed question to my friend. What was our ground in the writ appeal, in the writ petition? It was on jurisdictional grounds, my lord. For the reason, my lord, that the notice which was issued to us asked us, it spoke of a period, if Lordship kindly sees page 62, my lord. This is the notice issued by the department. Page 62 kindly be looked at, my lord. Page 62, my lord, is the start of the entire matter, the notice that was issued to us. Lordship may kindly look at the second last paragraph of this notice, my lord. If Lordship kindly looks at the second last paragraph of this notice, if I'm allowed to quickly read, my lord. Now, the scrutiny of the records maintained by this office for the remittances made by you during the period from 1/4/1996 to 31/3/2014.
Which paragraph you're reading?
Page 62, my lord, the notice, the second last paragraph, my lord. Second last.
Yes.
I'll read again, my lord. Now, the scrutiny of the records maintained by this office for the remittances made by you during the period from 1/4/1996 to 31/3/2014 shows that there are certain payments. It goes on, my lord. Our point, my lord, was very simple. This notice, my lord, was issued in 2021, asking us to produce records from 1996 onwards down to 2014, my lord. So, my lord, if the quick calculation is done, this notice is asking us to produce records, etc., for a period almost 25 years back, and the earliest period being about 7 years back, my lord. So, the first point that we had raised before the department and before the learned single judge was that even though 14B of the Act, my lord, does not specify a period of limitation, would it mean that the department has free license to initiate proceedings at any point in time, my lord? The answer, based on the law that was placed before the learned single judge, various judgments of the various high courts, including the Honorable Supreme Court, the law was very simple, was very clear, my lord. 14B may not have a period of limitation prescribed, but that does not mean department can take up proceedings at any point that they see fit, my lord. So to ask us to produce documents from 25 years back causes prejudice to us, my lord. And prejudice, my lord, on a factual basis, if lordship looks at page 70.
Yes.
Page 70, my lord. Most of the inability of ours to produce documents from so far back related to bank transactions, bank accounts, bank statements. Now, we had asked SBI to kindly supply the required documents. SBI categorically sent this letter, categorically stating, if lordship allows me to read.
Yes.
At page 70 is the SBI letter.
70, Lordship.
70, my lord. We refer to your letter number so-and-so, wherein you had requested for account statements for the year so-and-so, so-and-so. We regret to inform that as the records pertain to periods before the bank was fully computerized, so we would require some more time to make these statements available to you. The necessary requests have been placed to our data archival center. The same would be sent to you as soon as possible. We regret the inconvenience caused in this regard. Till today, my lord, SBI has not supplied any statements. Naturally, my lord, 25 years back, it becomes a little difficult. So all of this, my lord, was
So your first ground is long delay.
Reasonable exercise of power under 14B, my lord.
No, unreasonable delay
Delay, my lord. Delay.
with regard to the period covered.
Absolutely.
All
So,
right. And second point?
Lordship, second point, my lord, page 88 may kindly be looked at.
So what is the point?
The point is very simple, my lord, violation of natural justice. I was not even heard. Page 88 may kindly be looked at, my lord.
Yes.
Page 88, if Lordship kindly sees. Page 88 of the memo of appeal, my lord. Page 88. Page 88, my lord, is, as Lordship would have seen, under 14B, I am required to be heard. Finally, in the middle of the proceeding, I was allowed to give my show cause reply, my lord. 25th May 2022 was my reply. Now, if Lordship just flips the pages, Lordship will see this is a very comprehensive reply where, in addition to the factual parts, in addition to the factual part of the matter,
No, have they shown anywhere their calculation of damages?
nothing. And we are very thankful for Lordship noticing this factual weakness on merits of the department's case. Under 14B, you are required to impose damages not exceeding the arrears. But nowhere have they said this is the arrear, and therefore, as per this calculation, we are imposing this much damage. Nowhere. Lordship, I was pointing, my lord, to the show cause which I had filed. This show cause, comprehensive show cause, my lord, it is very important for this honorable appellate forum to kind of see how have they dealt with my show cause, my lord. If Lordship looks at the impugned, the order passed by the department, page 101, my lord. So I have filed a detailed, comprehensive show cause, touching on all parts, on all aspects of the matter, including the law which says you cannot take up proceedings beyond a reasonable period. How have they dealt with my show cause, my lord? Page 101. Page 101.
Yes.
The last paragraph, my lord, I'll quickly go through it, my lord. Last paragraph, Shri so-and-so, secretary, however, sought more time and stated that the detailed and comprehensive explanation of the queries of EPFO Shillong will be submitted along with relevant documents on the next date of hearing. The submission of Shri so-and-so is taken on record and the next date of hearing was fixed on so-and-so at 11 a.m. Shri so-and-so, secretary of the establishment, attended the proceeding on 6/5 so-and-so and he prayed for more time to find the records required by EPF office as stated in the previous hearing dated so-and-so. The request is granted. The next date of hearing was fixed on 25th May 2022. On Lordship, very clearly reflected. The next date of hearing was fixed on 25th May 2022. On 25th May 2022, Shri so-and-so, secretary of the establishment, attended the proceeding and submitted a letter reference number so-and-so dated 25th May 2022 and case was adjourned to 21st October 2022. My lord, I'll pause. My lord, what I was highlighting, my lord, is that on 25th May, I submitted my show cause. It is reflected in the order on so-and-so, I attended the proceeding and submitted letter number so-and-so, which was my show cause. Next date fixed on so-and-so. Now, what have I said in the show cause? What is the ground that I'm taking, the defense I'm raising?
Their show cause is dated 3rd February.
My lord?
Their show cause is dated 3rd February.
Their notice, my lord, is dated 3rd February.
The order date is 3rd February.
Sorry,
Show cause notice.
show cause notice is different, my lord. The notice is dated 31st October 2021,
Where do you get that?
page 62. 62. (31st 10/31/10/2021) is their initial show cause notice, initial notice to me. Subsequently, my reply, my show cause, my objection was filed on 25th May 2022. May 2022 is my objection. And most importantly, my lord, my objection has not been dealt with. The comprehensive objection which I filed on facts and law, no reflection in the impugned order. The only reflection is I submitted my objection. Next date fixed on so-and-so. No attempt to address my objections. No attempt to address my objections. No attempt to deal with the law which I have placed in my objection. In other words, in very simple terms, my lord, I was not heard. Now, if that is the position, if an authority lacks jurisdiction, my lord, to act in a particular manner, number one. Number two.
Why it lacks jurisdiction?
Jurisdiction in the sense, my lord, as I had submitted some time back, the law is clear from the Supreme Court and High Courts that even though 14B does not contain within itself a period of limitation, this does not give an open license to the department to initiate proceedings as and when they would like. So, in other words, my lord, the concept of reasonable period has been, in a way, formulated. And Supreme Court has gone one step further. Supreme Court has come up with the concept of irretrievable prejudice, my lord. In case the proceedings being sought to be initiated by department is causing irretrievable prejudice for the...
Here you see the learned judge has, all right, let us take it very rightly, set aside the order for these errors.
Yes, ma'am.
Now the court will not decide this, damages 14B.
Absolutely, ma'am.
So it should be remitted back, and that is what they want. What is your problem?
No, my lord, what they want, if I've understood correctly, my lord, subject to correction, is that instead of a writ petition...
Either on appeal or before the court or adjudicator of first instance.
Yes, my lord.
From the case you have made out,
My lord.
or you are trying to make out,
My lord.
if we accept that case,
Yes, my lord.
we would, instead of sending it to the appellate authority,
Yes, my lord.
we would send it to the first authority again.
Yes, my lord. Lordship, that
We
option...
will not decide the 14B claim.
No, my lord. This honorable writ court should not, in fact, enter that field. What I was saying, my lord, is that what lordship is proposing would be the
Because
normal...
the learned judge,
Yes, ma'am.
maybe out of inadvertence,
Yes, my lord.
has stopped there,
Yes, ma'am.
has set aside.
Yes, my lord.
Thereafter what?
No, my lord. What I was trying to impress upon this honorable court is that under normal circumstances, sending it back, remanding it back to the department would be permissible. But here, these circumstances are...
No, there is delay. All right, there is delay.
My lord.
And the Act does not give any power to anybody
Yes, my lord.
to remit the damages altogether. It might be re-won,
Yes, ma'am.
rupee one,
Yes, ma'am.
but provided it is not more than the amount which is due,
My lord. My lord.
damages has to be imposed.
My lord.
So it is also not the learned single judge's finding that there should be no damages in the case because all amounts were deposited within time, which finding I am entering.
My lord.
So damages have to be assessed. If damages have to be assessed, The writ court will not assess it.
Writ court will not, my lord. What the writ court has done, what the learned single judge has done is, based on the law again, has come to a finding that though 14B gives you a power to impose damages, etc., that power has to be exercised within a reasonable time, my lord. And that is the law from the Supreme Court down to various high courts. That power has to be exercised within a reasonable time. You chose to sit upon the power that you have been vested under 14B. 25 years later, you come up and say, show me this document, and that document would be an unreasonable exercise of that power. So, Lordship's proposal, if I can call it that, my lord, to remand the matter back would be applicable.
We will keep that point also open. That you reconsider absolving the noticee of damages for that period which is unusually long.
My lord, since we are before this on
Treating it as barred by limitation, in other words.
yeah, because to say that, my lord, would be with respect, my lord, would
No,
be
we cannot say it because the
Yes.
government period of limitation is 30 years.
30 years, and 14B itself does not contain any period of limitation. My lord, remanding it back, since this issue is already seized off by this honorable well-equipped forum, my lord, I would humbly request that whether department has the power to open a case after 25 years, like in our case, that issue may be decided by this honorable forum itself instead of remanding us back. Because at some point down the line, my lord, we anticipate that we'll again be standing before this honorable court, agitating the same issue, that 25 years is too unreasonable a period. If Lordship gives me just 2 or 3 minutes time, I'll place the law also, my lord, in this respect, including Lordship's own judgment from Calcutta High Court, if Lordship allows, my lord. This is a small compilation I've taken the liberty of preparing, my lord, of the applicable judgments. Page 1 itself may be looked at, my lord. This is a 2015 judgment. 18 of this judgment, very simple proposition, my lord, at page 2 of the compilation. Page 2 of the compilation, my lord, para 18, very direct proposition of law, my lord. Page 2, para 18, my lord. It is a principle of law that though Section 14B of the Act does not provide for any limitation for initiation of proceedings for levy damages, but the power should be exercised within a reasonable period. Very simple. There cannot be any quarrel with that proposition, my lord. Page 6, my lord, page 12 is the Supreme Court judgment, which has gone one step further, my lord. Page 12, Hindustan Times, this is a 1998 judgment, and Lordship is very well familiar with this judgment. Para 25 of this judgment, my lord. That is at page 14 of the compilation. Para 25, I'll read, my lord. Gujarat High Court in Gandhi Dham Spinning and Manufacturing versus so-and-so laid down a principle that prejudice on account of delay could arise if it was proved that it was irretrievable. There it was observed that for purposes of Section 14B, there is no period of limitation prescribed, and for that any negligence on the part of the department in taking proceedings the employees who are third parties cannot suffer. It was further observed. The only question that would really survive is the one whether on the facts and circumstances of a given case, the show cause notice issued after a lapse of time can be said to be issued beyond reasonable time. The test whether lapse of time is reasonable or not will depend upon the further fact whether the employer in the meantime has changed his position to his detriment and is likely to be irretrievably prejudiced by the belated issuance of such a show cause notice. So I have changed my position in the last 25 years. I have gone from CDA to IDA payment system. Number one. Number two, 25 years back, records are not available with me. I have categorically placed it before the department in my objection show cause that even the
Supreme Court judgment is which paragraph?
my lord,
Supreme Court judgment,
is 25 and 26, my lord. 26,
the Gujarat High Court.
25 is where the Gujarat High Court is reflected. 26 is the Supreme Court's own judgment, if I'm allowed to read, my lord. 26, next paragraph. A different aspect of prejudice was referred to in Shushma Fabrics versus Union of India by a learned single judge of the Bombay High Court. It was thus stated that in some cases, there could be serious prejudice on account of abnormal delay in taking proceedings under Section 14B, either because the records or accounts of the defaulter are lost, my case, my lord, or on account of the personal concern acquainted with the facts of a bygone period no longer being available for unearthing the facts, again, my case, my lord. But such pleas must be raised before the department and strictly proved. In case such facts are proved, it is possible in some cases that there is irretrievable prejudice. Now, my lord, these, whatever is the law, and there are other judgments also, lordship is very well familiar with this aspect. If I'm allowed to place lordship's judgment from lordship's earlier. Lordship's earlier rule in the Honorable Calcutta High Court.
You have cited 1998.
1998, my lord.
SCC.
1998, 242.
Paragraph 25, 26.
26 and 29 is also there, my lord. If lordship has that.
My also submission is from 17 to 29, lordship. The lordship 29 is, I am also referring the same judgment for paragraph 29, lordship.
Lordship, just going back to the Supreme Court judgment, if I'm allowed to read para 29 also, that is at page 16 of my compilation, my lord. 16. Or if Lordship chooses Lordship's own judgment from Honorable Calcutta High Court. If Lordship has the Calcutta High Court judgment from 2015,
Yes.
page 4 of Lordship's judgment, my lord. Second paragraph, my lord, or at page 4, in Hindustan Times Limited, the 1998 judgment which I just cited, my lord. In Hindustan Times Limited versus Union of India, reported in EIR 1998, Justice Rao emphasized the need to pass a reasoned order under Section 14B after hearing the parties. I was not heard, my lord. The factors which ought to be taken into account by the Regional Provident Fund Commissioner are the number of defaults, the period of delay, the frequency of defaults, the amounts involved, the delay in realization of debts of the employer, and the irretrievable prejudice to the employer caused by delayed recovery by the Provident Fund Authority. Power cuts causing reduction of production and income were also a factor to be taken into account. This is important, my lord. Mens rea or absence of willfulness as a factor for determination of damages under Section 14B was emphasized. That is my third point, my lord. I'll just come to it shortly. In a case under the Employee State Insurance so-and-so, Mr. Justice Sabyabrata Sinha in so-and-so versus so-and-so opined, a penal provision should be construed strictly only because a provision has been made for levy of penalty. The same by itself would not lead to the conclusion that penalty must be levied in all situations. Such an intention on the part of the legislature is not decipherable from Section 85B of the Act. When a discretionary jurisdiction has been conferred on a statutory authority to levy penal damages by reason or an enabling provision.
You can come straight away to the last paragraph.
Yes, my lord.
Analysis of the above
Yes, my lord. I was just coming to that. Yes, my lord. Just summing up, my lord, from an analysis of the above authorities, the principles are these. Section 14B vests in the Central Provident Fund Commissioner or any other officer authorized by the central government the power of recovering penalty. B. Under the said section, the penalty could be specified in the scheme but could not exceed the amount of arrears, Lordship has already observed. The word may in the section is to be construed as directory and confers a discretion on the above authorities. D, in the exercise of this discretion to award penalty or damages or reduce it, factors such as delay, frequency of delay, the number of days, delay, and other factors like power cut, non-realization of debts by the employer, the delay on the part of the authority to claim the damages, thereby causing irretrievable injury to the employer, could be considered. Although the Provident Fund Authority could reduce the amount of penalty or damages, this discretion could not be used to waive it altogether. The introduction of so-and-so in the employee so-and-so scheme 1952 did not alter this discretion. The other points, this is on the facts. This is on the facts. So, my lord, the third point which I just touched upon just now was on mens rea, my lord. Now, mens rea, my lord, if lordship kindly looks at my compilation, the index right at the front, my lord, lordship will see judgment at serial number 5 is a Calcutta High Court judgment, my lord, and more heavily, my lord, judgment at serial number 6 is a Supreme Court judgment on mens rea under EPF, page 20, my lord. Now, in this Supreme Court judgment, what had happened was that High Court had taken a view.
This is the third case you are citing.
Third point, my lord.
Third case.
Third case also.
First 1998 2 SCC, second 2015 SCC online Calcutta.
Yes, my lord.
And this is the third one.
Yes, my lord. Now, in this judgment, what had happened in this case? What had happened was High Court had taken a view, my lord, that mens rea, finding on mens rea, is essential for an order to be passed under 14B. That was challenged by the department, my lord, before the Supreme Court. Supreme Court's finding, my lord, very succinct finding, para 2. High Court has taken a view that in the absence of a finding regarding mens rea actus reus on the part of the employer, action under section 14B of the EPF and miscellaneous provision acts cannot be sustained. Next page, my lord. The issue is now wholly covered against the appellants in the decision rendered by this court in McLeod-Russell, which lordship has also referred in lordship's judgment, versus so-and-so, where it has been held in para 11 that the presence or absence of mens rea and or actus reus would be a determinative factor. The para 3, my lord. The presence or absence of mens rea and or actus reus would be a determinative factor in imposing damages under section 14B, as also the quantum thereof, since it is not inflexible that 100% of the areas have to be imposed in all the cases, alternatively stated. It goes on, my lord. In the para 4, my lord, in the impugned judgment at para 23, it has been specifically held by the High Court that in this case, there is no finding rendered by the original authority or the appellate authority with regard to mens rea or actus reus, except
Which paragraph you are reading?
my lord, page 21, my lord, of the Supreme Court judgment. Page 21, para 3. The issue was whether mens rea is required under 14B, my lord. Answer, my lord, para 3. This issue is now wholly covered against the appellant in the decision rendered by this court in McLeod-Russell India Limited versus so-and-so, wherein it has been held in para 11. That the presence or absence of mens rea and or actus reus would be a determinative factor in imposing damages under section 14B, as also the quantum thereof, since it is not inflexible that 100% of the areas have to be imposed in all the cases. Alternatively stated, if damages had been imposed under section 14B, it will only be logical that mens rea and or actus reus was prevailing at the relevant time. Para 4, in the impugned judgment of the High Court, at para 23, it has been specifically held by the High Court that, in this case, there is no finding rendered by the original authority or the appellate authority with regard to mens rea or actus reus, except saying financial crises cannot be a reason to escape. In view of the above, these appeals are dismissed. So the High Court's finding that mens rea is an essential finding to be reached at. So the High Court had found, my lord, that the mens rea is essential when you're imposing damages under 14B. You have to locate, identify, and record that mens rea. That was not done. High Court said your order has to be set aside. Supreme Court confirmed it, my lord. So mens rea, my lord, would be my third point.
So you have not cited 2022 STC, Calcutta. You are citing 2017 Supreme Court.
Yes, my lord, but it's on the same point. 2022 SCC, Calcutta. I was thinking, my lord, maybe the Supreme Court would be more persuasive, my lord. But it's on the same point.
No, but the compilation may have 40 cases.
Yes.
But if you cite 5, we can only rely on 5.
Understood, my lord. Appreciate that. If Lordship also kindly allows me number 5, that is 2022 Supreme Court, Calcutta, my lord.
But please don't make any duplication. If
Very good.
Supreme
So
Court
I'll-
covers this case.
That was the reason, my lord, I had sort of not gone there, my lord. So, my lord, the picture that is before my lord, and Lordship would have seen it, is picture, my lord, is that the 14B does not have limitation. There's no quarrel with that proposition.
The period is 2015 to
My period, my lord.
1995 to what is the subject matter of the 1st
1st April 1995 to
1 minute.
1996, sorry, 5 or 6, 1990, 1st April 1995, my lord, to 31st March 2014. So roughly, my lord, if I'm allowed to calculate, about 25 years back, stretching 25 years back, and 7 years prior, 7 years back also. So the latest period is 7 years back. The most ancient period is about 25 years back.
And notice
Is dated
6 to 21.
No, 31st October to 21, page 62.
So what is 6 to 21?
6
I
to,
asked you, you showed that date of the so-called notice.
6 to 21, my lord, there is nothing significant. 6 to 21. Six to, my lord, nothing happened because
23,
6 to 23, my lord.
103. This is the adjudication order.
My lord.
And the so-called notice is
31st October, 31/10/21.
Adjudication order is 3-2, Lordship. 3-2.
So, my lord,
adjudication order is come to page 103, 6 February 2023.
6 February 2023. But the order was passed on 3/02/23 and it was signed on 6 February, Lordship.
These subordinate adjudications, we have to take the date of signing. In higher courts, the date of pronouncement.
Okay.
just one last point. Addressing one issue which my friend had placed right at the beginning of our submissions, that I should have gone for appeal rather than writ jurisdiction appeal under 7I, my lord. Now, my lord, again, the law is very clear. At the risk of repeating a well-established law, my lord, the last judgment at serial number 9 of my compilation. That is at page 27 of the compilation. Very well established, my lord, Whirlpool Corporation.
That Whirlpool judgment.
Yes, my lord. So I need not.
2006 or 4.
98, my lord. 98.
98.
98, my lord.
Page 1.
Page 1. So, my lord, Whirlpool is very clear that there may be a provision of appeal.
2006 is that Uma Devi. So both are page 1, we remember. Cited very often.
Yes, my lord. Yes, my lord. So Whirlpool is very clear, Lordship is familiar with it, my lord, that appeal provision may be there, alternate remedy may be there. However, if the action of the order is without
jurisdiction, natural justice, etc., arbitrary,
then writ jurisdiction is not barred. My case, my lord, I was not heard. My show cause was dealt with in one line. I have submitted my show cause. Nothing. No address of whatever defenses I have taken. So 14 requires me to be heard. You have repeatedly harassed me for documents. That is not a hearing. When I finally give a response or defense, you deal with it in one line saying, I have submitted my reply. What I have said in my reply, how do you address that? The impugn order is silent, my lord, absolutely silent. So 7I appeal alternative remedy, my lord, I submit humbly. That should not play a part. Jurisdiction is very well open to me, my lord. Now, my lord, going back to what lordship had proposed, remanding the matter back, my lord. Lordship, I would humbly submit.
We have understood you want a remand with the attending order that anything from 1995 to so and so is quashed. The latest period you consider, I can understand, we will consider.
Very great, very great.
Lordship, further Lordship, what my learned friend is submitting that we have not taken into consideration, Lordship. Page 102, Lordship. Page 102, Lordship. 1, 2, 3. Fourth line, Lordship. Fourth line. For the wage month, the contention of the establishment is rejected as on scrutiny of the challans submitted by the establishment. It is found that there are variations in the amount reflected in the annexures A and the challans submitted by the establishment. So we have taken into consideration, Lordship. We have rejected their whatever they have submitted. Further, Lordship, we have on whatever they have submitted, we have given them a revised calculation sheet, Lordship. We have submitted a revised calculation sheet. Then further in the same line, Lordship, 1, 2, 3, 4, fifth line. From that line, it is the fifth line. Fifth line, a revised calculation sheet was prepared and handed over to the establishment for perusal and their submissions before next date of hearing. After preparing the revised calculation sheet, Lordship, we have handed over to them stating that you consider that you scrutinize whatever we have given you and reply before the next date. Thereafter, we proceeded with the order, Lordship. It was not a case that their contentions we did not heard. Lordship, further, my learned friend has submitted some of the judgments, Lordship. I am also relying on the Hindustan Times, Lordship. Para 17, Lordship. Para 17, Lordship. The first contention on behalf of the appellant in the context of section 14B is that a period of limitation must be implied under law for, according to the appellant, it will be wholly reasonably to allow the power to be exercised after a lapse of large number of years. Now the Act does not contain any provision prescribing a period of limitation for assessment or recovery of damage. The monies payable into the fund are for unlimited benefit of the employees. But there is no provision by which the employees can directly recover these amounts. The power of computation and recovery are both vested in the Regional Provident Fund Commissioner or other officers as provided in section 14B. Recovery is not by way of suit. Initially, it was provided that the arrears could be recovered in the same manner as arrear of land revenue. But by the Act 3753, section 14B was amended, providing for a special procedure under section 8B to 8G. By the Act 4073, section 11 was amended by making the amount of first change on assets of the establishment. If the arrears of the employee's contributions were for a period of more than 6 months, by the Act 3338, the charge was extended to the employee's share for contribution as well. In spite of all these amendments, over a period of more than 30 years, the legislature did not think fit to make any provision prescribed for a period of limitation. This is, in our opinion, it is significant, and it is clear that it is not the legislative intention to prescribe any period of limitation for computing and recovering the arrears. As the amounts are due to the trust funds and the recovery is not by suit, the provision of the Indian Limitation Act are not retracted. In Nityananda M. Joshi versus Life Insurance Corporation of India, AIR it has been held that limitation has no application to labor courts, and in our view, the principle is equally applicable to the recovery by the concerned authority under Section 14B. Further, in Bombay Gas Company Limited versus Gopal Viva, it has been held that in respect of any application under Section 33C(2) of the Indian Industrial Disputes Act 1947, there is no period of limitation. In that context, it is stated that the courts could not apply a period of limitation. It was observed at page 757 of AIR.
757?
757 of AIR. The bracket is closed, Lordship. It seems that where the legislature has made no provision for limitation, it could not be open to the courts to introduce such limitation on the grounds of fairness or justice. The above discretion has been recently accepted in Mukri Gopalan and versus Chaplet, SSC dash. It was a party where dealing with the applicability of Section 29(2) of the Limitation Act 1963 to courts or tribunal. We also point out in connection that several high courts have rightly taken the view that there is no period of limitation for exercise of the power under Section 14B of the Act. It is true that the principle has been laid down in state of Gujarat while dealing with suo motu revisional jurisdiction, that though there is no period of limitation prescribed for exercise of that power, still such a power must be exercised within reasonable time. The state judgment has been applied in matters relating to Section 6 of the Land Acquisition Act in large number of cases, where which were all referred to recently in Ramchand versus Union of India. In our view, this line of case cannot ordinarily apply to monies withheld by the defaulter to hold them in trust. So the court has also stated Gujarat rejecting because this cannot be held in monies. In reason that while in the above cases decided by this court, the exercise of power by the authorities is very bad, at a very belated stage, was likely to result in the deprivation of property which rightly and lawfully belong to the person concerned. The position under Section 14B of the Act of an employer is totally different. The employer who has defaulted in making over the contribution to the trust fund had, on the other hand, the use of monies which did not belong to him at all. Such a situation cannot be compared to the above lines of cases, which involved prolonged suspense in regard to deprivation of property. In fact, in cases where Section 14B, if the Regional Provident Fund Commissioner had made computation earlier and sent demand immediately after the amount fell due, the defaulter would not have been able to use these monies for his own purpose or for his business. In our opinion, it does not lie in the mouth of such persons to say that by reasons of delay in exercise of powers under Section 14B, he has suffered loss. On the other hand, the defaulter has obviously had the benefit of the boon of delay, which is so dear to debtors, and as pointed out by the Privy Council in Nagendranath De versus Suresh Chandra De. In that case, it has observed that equitable consideration were out of place in matters of limitation, and the strict grammatical consideration alone was the guide. Sir Dineshwar Mullah stated, nor in such a case as this is the judgment debtor prejudice, he may indeed obtain the boon of delay, which is so dear to debtors, and if he is virtuously inclined, there is nothing to prevent his paying what he owes into the court. The positions of the employer in case of defaulter under Section 14B is no difference. So, Lordship, here in these judgments, the Supreme Court has categorically addressed regarding the 14B sections, regarding 14B.
You see, if you come to paragraph 28, it says delay is no ground to deny recovery. But then if prejudice is caused, if there is alteration of position, etc., the prejudice to him of an irretrievable nature, he might also claim prejudice on proof of loss. So typically Supreme Court ये भी होता है, वो भी होता है. So we have to decide.
My lord, in fact, I am completely with my friend. I am also saying that limitation is not applicable. But the law as it stands, including this judgment, Hindustan Times, my lord, it says that even though limitation is not applicable, that does not give you open license to initiate proceedings after years when irretrievable prejudice may be caused, my lord. So I am with my friend. Limitation does not apply. We are not asking or...
Their lordships have said in the first part of the paragraph, by not claiming it, you have enjoyed the use of that money and made profit out of it. See that first part.
Yes, my lord.
And the second part is, if the delayed claim
Yes, ma'am.
has resulted in prejudice to you,
Prejudice.
that means you were a thriving business when the claim could have been made.
True.
Now you are running in losses, now the claim is sought to be recovered.
Absolutely.
It will cause prejudice to you.
Yes, my lord.
In that case, the recovery would be prejudicial and not encouraged by the court.
Yes, my lord. And
So
that is...
these are the two. So
Yes, lordship is right.
Lordship, further
you
regarding
are
damages.
citing 98 Supreme Court, right?
Supreme Court. Further, I am also citing Oregano Chemicals, 1979 Lordship. Here, the para 13 regarding damages, the court has specifically answered regarding the damages also, Lordship. Para 13, para 18, relevant para. Para 46, para 47, para 48 and 49 regarding Oregano Chemicals, Lordship. Lordship, further in Horticulture, Lordship, para 14 and para 17 also, Lordship. Horticulture, Lordship.
Where is that Oregon case?
Oregano case,
What is? Oh, 79.
yes, 79, 20, page number 28, Lordship. Oregano case is 1979.
Paragraph?
Relevant paragraph is 13, 18,
Yes.
46, 47, 48, 49.
Yes.
And horticulture, paragraph 14 and 17.
1 minute. horticulture is unreported.
Yes. It is unreported, but it is mentioned as a reportable judgment.
Para?
For horticulture, it is para 14 and para 17.
Yes.
And the last one is Arcot Textile Lordship.
Yes.
For Arcot Textile, it is 2013. Para is,
No, AIR 2014.
yes, AIR 2014.
Yes. Para?
Para is 12, 13, 14, 15, 16, 17, 18, 20, 23, and 28.
Same proposition.
Same purpose.
Delay.
A delay. And
Lordship, I'm required to humbly point out, neither have I been given copies nor is my friend extracting the judgments. So I'm at a loss how to respond, or I've just been let go. Very well. Very well.
No, has it said that the organization would be completely absolved from payment? Or has it said?
no, Lordship, nowhere it is mentioned that the organization is completely absorbed from payment, Lordship. Because these payments goes to the delay, whatever the amount we have here, the Provident Fund is not getting benefits for their own, Lordship. It is for the beneficiary.
What is the ratio? That if it is prejudicial, then...
because it is affecting the pension fund, and the interest in the pension fund also is getting affected.
No, suppose it is delay and prejudicial, then what is the effect?
Lordship, the pension fund gets affected because it is...
Pension fund is not divided. What is the impact on the imposition of damages? It's a much delayed claim causing prejudice. Has the Supreme Court said anything?
Pardon, Lordship, I did not get, Lordship.
There are two parts of the ratio.
Lordship,
Number one, delayed claim
Lordship,
will not bar recovery of damages. No limitation does not matter.
Lordship,
And number two is, if the delay is such that prejudice is caused to the other party, then that delay will be taken into account
Lordship,
in mitigating the damages or reducing the damages to be imposed under 14B.
Lordship. But
Has the Supreme Court in these subsequent cases said something different from 1998?
Lordship, the different observations are there. The Supreme Court has dealt with the damages in that the damages has to be a part of the entire litigation's, Lordship. The damages cannot be waived off in such a way, Lordship. The Supreme Court has stated, Lordship.
All right.
And just on Lordship's question, my Lord, the answer, not a Supreme Court given answer, but a High Court given answer, my Lord, is at serial number 7 of my compilation. Karnataka High Court, my Lord, a period of 15 years. If Lordship looks at page 22 of the compilation.
ILR 2014 Karnataka.
That's right, my Lord. I'll just read the opening part, my Lord. EPF so-and-so Act, Section 14B. Initiation of action for belated remittance of contribution, proceedings initiated after the delay of more than 20 years. Our case, my Lord. By that time, the so-and-so, I'll just come to the operative part. It is needless to state that the Regional Provident Fund Commissioner, while exercising jurisdiction under Section 14B of the Act, read with so-and-so, levy damages by way of penalty for breach of the statutory obligation of the respondent employer to pay the contributions within time, fell in error in not exercising that discretion. When a statute does not prescribe a period of limitation for initiation of action, then such action must be initiated within a reasonable time. That is my contention also, my Lord. That I am also in agreement with all the Supreme Court judgments and my friend. Limitation it's not present. It cannot be read into 14B. But however, that does not give a carte blanche, my Lord, an open license to initiate proceedings after 20 years, 25 years. Today, if these proceedings are upheld, tomorrow, my Lord, department will come up 50 years back. They want records. That cannot be allowed, my Lord. That cannot be allowed. That's
Lordship, furthermore, Lordship, if damages are waived off, if damages entire,
Understood. No, reply to. It will go on like that. We have understood. You file your notes. Please take down. Hearing concluded. Stop CAB. Then that usual, either party to file written notes with the court master. By 4th March, 1 week.
1 week.
one,